In the last few weeks, I've had a number of potential clients reach out to me with very similar questions. It's either one side or the other. Do I need a power of attorney for my aging parent, or do I need to go down the guardianship route with my aging parent or loved one? Both a power of attorney and a guardian can make decisions for someone else, but they're very, very different documents and processes, and the cost, the length of time, the requirements are very, very different. So in today's video, I want to clear up for you what's a power of attorney, what's a guardianship, and what can I think about or do now in order to prevent trying to deal with resolving this in a stressful situation. So first of all, I want to explain what is a power of attorney. A power of attorney is a document that appoints an agent. An agent is someone that can act on someone else's behalf. Sometimes people say, this is my power of attorney. What they really mean is, this is my agent. Now, I'm going to talk about New York law right now. In general, you can have one or more agents under a power of attorney, either at the same time or one after the other. You can have all sorts of rules about if they need to make decisions together or if they can make decisions independently. And then there's a huge range of authority that this agent under a power of attorney could have. So, and sometimes it's for small things or specific things, like taking care of a very specific matter. Sometimes it's very, very broad. So you do want to be careful and thoughtful about who you appoint as an agent and what powers you let them have. The power of attorney you appoint now, and most of the time it's valid now, even if you're still fine. It doesn't take away your rights or powers. It just adds on that someone else can stand in your shoes and make decisions on your behalf. They're obligated to act in your best interests and according to the plan that you have for your property. So if you have a will leaving everything to your two children and you appoint your sister as a power of attorney, she can't redo your plan and make herself the beneficiary of all of your assets. Now, one of the things that's very different about a power of attorney versus a guardianship is that, first of all, you don't need to be incapacitated to have a power of attorney. I have one, and everyone should have one. Number two, you can revoke a power of attorney. If I make my friend my power of attorney and then I have a falling out with her, I can revoke that power of attorney and take her authority away at any point. Number three, you do have to have capacity to sign a power of attorney document. And what that means is that you need to understand what this means. Who is this person that you're appointing and what powers they might have? And that is a question that can be iffy when someone is diagnosed with dementia. That doesn't mean they cannot sign a power of attorney, because sometimes they might be better than others. But it does then come into question if that person had capacity to sign a power of attorney. So now I want to explain what guardianship is. I'm talking about what is called in New York Article 81 guardianship. For someone to need a guardian appointed, the legal standard is that they do not have capacity to understand what consequences their actions may have. That someone doesn't understand that if they don't pay their rent, they will be evicted and no longer have a home. Now, a guardianship is a legal proceeding. It's a judicial proceeding. So a petition is filed, a judge is involved. Usually an attorney is appointed to represent the subject of the guardian, what we call the alleged incapacitated person. There's a court evaluator. There's a big investigation. The court is going to be taking away someone's civil rights to make decisions on their own behalf. Because once a guardian is appointed to make certain decisions, the individual no longer has the right to make those decisions. There'll be a lot of scrutiny. There'll be a lot of examination. There's going to be quite a good amount of cost. Even in an uncontested guardianship, the fees could very easily come to $5,000 to $10,000. If someone is going to contest the guardianship, say this person doesn't need a guardian, or maybe they do need a guardian, but you shouldn't be that guardian, it can get much more expensive. In reality, it often feels like a child's custody battle. So that's a guardianship. When people come to me and they say, I need a power of attorney for someone with dementia, or I need a guardianship for someone, there are a few things that we want to take a look at before we make a decision about which road to go down. Number one, how contentious is the situation? Who are the parties involved? If someone comes to me and says, I'm the only child of my mother, or I am one of 3 children and all of us are on the same page. My mother has some dementia, but she can still talk and understand things. And we want to have a power of attorney because we want to help her deal with her daily bills. She doesn't really have any substantial assets. She's already on Medicaid. We just want to help her manage her daily affairs. Well, in that case, even if she has a dementia diagnosis, being that there's no opportunity for the power of attorney to really do anything improper, being that all of the involved family members are on the same page and agree that mom has capacity, even though it's limited, to sign that power of attorney, a power of attorney might be appropriate there. A guardianship may also be appropriate, but since it's a lot more expensive, a lot more stressful, and a lot more time consuming, a power of attorney might be a great way to go. On the other side, if someone comes to see me and says, my mom has a lot of assets, she owns a home in Brooklyn, I have a brother that I haven't spoken to in 20 years, and I want my mom to sign a power of attorney because I want to do some Medicaid planning and set up a trust and make myself the sole beneficiary. I'll inherit everything when she goes. To me, there's a lot of red flags there. That's a situation where guardianship might be much more appropriate, because I think you can imagine that son is going to come back into the picture and say, what's going on? I maybe had a falling out with my sister, but not with my mom, and she's cut me out of the picture entirely. This is a very simple explanation about powers of attorney and guardianship, but I hope you get the idea. It's very, very fact specific. If you have any questions about whether or not a power of attorney or a guardianship is appropriate for your family member, please feel free to call our office. I'm Yana Feldman. I practice elder law and estate planning in Brooklyn, New York, and we would be happy to speak with you.